And court does call the case of the people of the state of Michigan versus Zachary Rao.
Good afternoon, Your Honor. Jacob Kennedy on behalf of the people.
James Thomas on behalf of Mr. Radcliffe.
I don't know, Johnny, on behalf of Mr. Radcliffe, Your Honor. I do believe that we filed an appearance on my behalf of Mr. Radcliffe.
Yes, we have the appearance. Mr. Radcliffe is now present in the courtroom. And sir, if you could say your name so that the camera comes toward you so they can see that you're here.
Yes, Zach Radcliffe.
All right. So he is present in the courtroom. Just by way of introduction in this case, so that everybody's up to speed is in terms of what happened on last Friday. What day is that? The 7th. Well, even before then, counsel for defendant had filed a motion to dismiss, filed a supplemental pleading that contained letters of support for the defendant that the court reviewed. That came through as a filing to the court. On the date of the motion, on the date of the hearing, certainly there were people in the courtroom that were agitated. Certain people came to our attention just in terms of their actions and other things, both my attention as I was looking out at who was here, as well as my bailiff's attention. There was one individual that my bailiff had reported to me that he spoke to just to make sure that there was nothing that was going to occur. Subsequent to, so that was on a Thursday, and I don't believe that it was the next Thursday. My dates are a little off a little bit here, but anyway. At that hearing also, Mr. Thomas presented additional letters of support for the defendant. I received those at the bench. They did not sort of come through and were filed as that supplemental report was. I retained those in my office file because of the way that they had come to me. I had taken a break during that proceeding at some point and reviewed those. That next day, the same individual that my bailiff had spoke to, as well as the person that had come to my attention, it was reported, we found out it was that same person eventually, but my clerks had reported to me that someone was at our front counter seeking to get the information regarding who had supplied the letters of support, specifically the ones that Mr. Thomas had presented to the court in court that day. That raised an alarm on the court's part as to why someone would want that information. I guess so that the record is all clear, I then got the file from the clerk's office, set a hearing, had my office email counsel, set a hearing regarding a protective order or something regarding those particular activities, and basically held the file so that until we could sort of resolve or try to resolve this issue. We were informed, I don't have the entire email, certainly counsel could speak for themselves. Upon setting the hearing, I think Mr. Thomas had indicated that he was looking into things as some of the people, and Mr. Thomas certainly correct me if I'm wrong on this, that had supplied those letters, that they had been doxed in some way and their information in some way disseminated or provided.
Ah, yes, another day in court where some people think throwing a handful of support letters is the golden ticket to innocence. Meanwhile, the judge is out here actually doing the job, spotting the sketchy behavior, locking down sensitive info, and making sure this doesn't turn into some vigilante justice mess. But sure, let's all pretend the real issue is how many friends the defendant has, instead of the fact that someone's out there snooping around for names like it's an amateur detective club meeting. Maybe next time, they should focus less on courtroom theatrics and more on not making the judge babysit their mess.
The prosecutor's office also made me aware of, after that, but prior to the hearing, that there are individuals, and I'm going to say it in this way, that could potentially be viewed as acting in concert with the defendant. And when I say it that way, I'm not saying that they are. I'm just saying it could be viewed that way. We're contacting victim or victims' families in regard to this case. And so that was the last kind of thing. There was certainly an email regarding certain discovery issues and other things that went back and forth. But the purpose of the court's hearing today was to hear from counsel and to try to figure out if we can a way that this can be alleviated and use what powers the court has to try to stop it from occurring while everybody proceeds to this process. All right. I say that all as a preface. That's kind of where we are. I think both sides kind of do most of that, if not all of that. And I'll do that. So, Mr. Thomas, maybe it makes more sense to sort of hear from you, I guess, because you were looking into some things in regard to it. So,
Yes, sir. So I'm going to leave the names out for purposes of, I don't want to put them on the record, but I was contacted by supporters of my client, obviously, and I had learned that there were names that were being doxed from the letters that we submitted as an attachment to our supplement. Obviously, it rose concerns because I didn't learn of that till obviously after the hearing had already been conducted. Had I thought about it, I probably should have submitted them under a protective order in the first place. So that's kind of on me that I didn't do it that way. I just didn't think that it was going to rise to the level of where we're at right now with the people on the other side of this equation. To address the court's concerns regarding whether these people are in concert with my client or not, I can assure you that I've had meetings with most of the people that are involved, the ones that have been coming to the normal court dates, and I have specifically told them, do not talk to these people. Do not reach out to them. Do not call them. Do not email them. They all know. The family knows, and everybody else knows not to engage with them in any sort of way. And they have not. We have not gotten any reports from anybody that anybody from the defendant's side have contacted anybody on the prosecutor side. Now, that's not the same that we're getting from the other side. Of course, we're getting messages from people, and I really don't want to go there because I'm not personally involved in this, Judge. I'm the lawyer. I have a job to do to defend my client. I'm not personally involved with the emotions that are involved in this case. I'm a lawyer. I'm a lawyer that protects the Constitution and my client's rights. And so that's how I feel about it. That's what I've been engaged to do. I am technically a mercenary to defend my client, and that's it. The emotional stuff that is going on between the families and of the victims and the family of the defendant are, to me, those are things that should not be in the courtroom. Obviously, at some point, I'm going to address those things because if we end up going to trial and there's noises or gasping in the crowd, I'm going to move for mistrial, and I'm going to do whatever
I don't need to know your trial strategy, counsel. I really don't.
No,
that's not what I'm here for. I'm not here to talk about you. I'm not here to talk about anybody. I'm here to try to deal with making sure that things don't come out of this that I don't think any of the parties here intend. And so when I set this, my issue was to certainly listen to counsel as to how to do things. There is a individual, and what I will do is I will have my staff, and rather than put the name on the record or the phone number that's contained in here, can we scan and send? I realize I only got you.
Oh, what a masterpiece of legal deflection. The defense lawyer, in a grand display of, "I'm just a humble servant of the Constitution," casually shrugs off the chaos, as if letters magically leaked themselves and supporters just spontaneously decided to reach out to the victim's family. And of course, in the middle of a serious discussion about courtroom decorum, we get the classic, "if I hear a gasp, mistrial" move. Because clearly the real threat to justice isn't intimidation, but someone in the gallery breathing too loud. Meanwhile, the judge, somehow still patient, is just trying to stop this circus from turning into a full-blown disaster.
No, it's okay.
Can I scan and send this to Mr. Thomas and we'll address it?
You want this done right now?
Yeah,
Yes.
I want that done so that we have that.
Judge, if I may just say one more thing about these letters, they've been put out on social media, and they're being used specifically to attack the people on social media and the church that my client's father is the pastor at. So they're doing it for other reasons other than just to retaliate. They're doing it to try to punish them economically, socially, and everything else, trying to shame them. So it goes a lot deeper. So do I think a protective order needs to be put in place by the court, for this? I absolutely. I mean, again, it's your choice. You can do whatever you want. And again, I'm not, personally, emotionally involved in this, but I mean, obviously, if the court thinks that, this has gone above and beyond what needs to be done. I mean, this is a one defendant that there's allegations against, not the family, not the church, not the pastor, and for these people to go and take these letters that people that support my client has got no bearing on those other things. They're doing it just to be ugly. And so I think the court can use its discretion to put a protective order in place against that, if the court so deems. My other concern is that those letters I gave the court, I did not file. And so I told the court that I was going to file them until I learned about the doxing, and I decided I was going to hold off to see exactly what was going on social media. So I don't know how you want me to address that. If you want me to,
You're talking about the letters that you presented in court.
yes, sir. The ones that I didn't
Okay.
have time that we submitted, that I got at the last minute. So there's nothing in the record other than you saying I got them, and obviously the names and all that are not part of the record. But if you want us to do it under a protective order, to submit those other letters that I gave you, so they'll be part of the file but be protected, I'm happy to do that if that's what the court wants me to do.
Understood. Mr. Kennedy.
Yes, Your Honor. Just a couple of things. As the court knows, I, as well as Ms. Reiser and the rest of our team on this matter, were not aware of any doxing taking place until just now, which has been indicated by Mr. Thomas. I do want to make sure that I'm clear as to what has actually transpired. If there are these letters that are being placed on Facebook, of course, I am concerned about people's personal information being placed out on social media platforms. I will say, however, that simply being present in the courtroom would indicate to others, I mean, we were all there on the night of the hearing, being present in the courtroom and sitting on a specific side indicated to the public and those who were within that proceeding who was being supported. And therefore, those members of the courtroom going out and indicating to others that so-and-so was on his side, so-and-so was on our side, is simply something that I don't think can be controlled. I don't think that it can be controlled in terms of the community of Saline, in terms of the greater Washtenaw County community. I think we all are certainly in an understanding that this is a case that has deeply impacted the community, has deeply impacted this church, and has deeply impacted the victim.
Ah, yes, the grand tragedy of the internet, where suddenly the defense is shocked that letters meant to support their client have made their way onto social media. Because, of course, handing over documents in open court in a high-profile case was totally going to remain a secret, right? And now, it's all about the poor church and the defendant's family, as if the actual victims are just minor background characters in this saga. Meanwhile, the prosecution, ever the realist, is basically saying, look, if you sit in a courtroom on a side, people can see you. That's how eyes work. But sure, let's pretend this is all some grand conspiracy and not just the inevitable consequence of defending someone in a case that has the whole community watching.
And the defendant. So I understand that protective order on the letters will certainly prevent this personal information that is placed in these letters from being further disseminated to the public. And in safety concern being of the utmost priority, I would agree with Mr. Thomas, and I would agree with the court. I believe that a protective order would be warranted, but I don't think that it's almost as if this has gone to the point of no return, almost. Simply being physically present in the courtroom and sitting on an individual's side indicates a support, and we just simply cannot control what people are going to say within their own community about those other individuals. So I am concerned about the doxing. I would ask this court to please make me aware if there's anything else that has happened. And as I've indicated previously, we were unaware. I've spoken with the officer, spoken with our victim advocate, and they were also unaware that any doxing had taken place prior to this week. So all that is to say, would be in favor of a protective order in order to secure the safety of the community. And I would like to say thank you to the court for bringing this to our attention. It is indicative of the court's desire to make sure that the community is safe.
And here's what I'm going to, and having listened to both sides, here's what I'm going to do, unless I hear an objection. Mr. Thomas, the supplemental document, the attachments to the supplement, the letters that were contained, I'm going to separate those out. I'm not going to strike them, certainly, from the record. But what I'm going to do is I'm going to place those as well as the other letters in a confidential portion of the file that won't be released to the public if somebody comes to look at it. I'm basically going to put a sort of check system in place that if somebody wants to look at it, it should come to the judge and then make a determination. So if for whatever reason you needed a copy of it, if somebody from your office needed a copy of it, you wouldn't be able to walk in and get it, but you contact the court, we would be able to get a copy to you. That way, I think because I have to balance making sure that the record that's there is complete, with the same time not making sure that individuals can't walk in. So that's the first thing that I think the court's going to do. I would also indicate to counsel that and I will draft an order to that effect as to what specifically I'm going to do. But I would also indicate to counsel that if there are other documents or other things that would contain personally identifiable information, almost defined in its broadest sense, that you provide a copy to the court if you are filing it, that you redact that information from what is filed, so that the contents of whatever, so if there were the letters, the redaction at the top of maybe name and certainly address and phone number and email would be done, so that it could be filed. If you have a question as to that or some issue, then certainly at any point you can bring that to the court's attention on that. I would also indicate that, and I understand Mr. Thomas's position in terms of his obligation, certainly to his client, and the like, but I think all of us as officers of the court are responsible for the operation of the court, the smooth operation of the court, and making sure that people are able to participate in our system without any fear or favor. So I do think there is an obligation on counsel to say something that doesn't obfuscate what one's primary objective may be. But I think that obligation does go there, and I would encourage counsel to talk to all of those individuals involved. I have, Mr. Thomas, had my staff send to your office a text message. I am not, did you emailed that with a...
Oh, look at that. Finally, a voice of reason in the courtroom. While everyone else is busy playing who's the biggest victim and pretending they didn't see the social media dumpster fire brewing, the judge is out here actually doing their job, keeping the record intact without turning it into free public entertainment. A little common sense sprinkled with a side of, yeah, you can't just waltz in and grab confidential stuff like it's a library book. And let's not forget the gentle but firm reminder that, shocker, lawyers have a duty beyond just winning arguments. But sure, let's keep acting surprised that the internet is messy.
Is there an attachment to it?
I did, sir.
All right. And I'm not going to say the name of the person. This, as I look at it, this is alleged to have been sent to one of the victims. It is also alleged that the individual sending it is a member of your client's family in some way. So I doubt very much I'm going to do anything with that at this point in time. I want you to be aware of it. And I think, as I would say, with your obligations, I think that any member of the bar has its obligations to the court and our system, that you take some appropriate action potentially to address it with that person, or since the person is related to the defendant, as I'm to understand, maybe something from the defendant regarding that would also be helpful. But I will leave that to your discretion as to what to do with that. I mean, when I look at the contents, I could frankly take it in a way that it sort of means nothing. I could also take it in a way that it could be the beginnings of a threat. And so and I just don't know what it means. I'm trying not to jump to any conclusion regarding that, but I think somebody may be lashing out, or the defendant. But sometimes you can have family members that lash out. It's not always necessarily in one's best interest. They're lashing out because of what they feel and what they believe. Okay, so what I will do, and I will leave it at this, counsel, I will, having heard from you, I will prepare an order. This has been a heck of a week, so I will try to get it out by Monday to counsel so that you have it, you can look at it, or actually Tuesday because of the holiday, and so that you can look at it. In the meantime, as I've indicated, the letters that were filed with the court are going to be placed in a confidential part of that file that no one will have access to. All right.
So
anything else?
Need to do
Go ahead.
with those letters in, Your Honor?
Pardon?
So you're saying I don't need to do anything else with those extra?
No. You don't need to do anything. We'll be good with that. The court has reviewed them. The court's made its ruling on the motion. I don't need that. They'll be part of the file, just not where someone can access.
All right.
Okay.
Yes, sir.
All right. Anything else from either side?
You have anything?
Your Honor, if we just let the prosecutor know, we will email him some additional information requests. We don't want to take up the court's time on that, but we will send it out this week.
Well, I'm sure they'll look forward to getting it, see if they can respond.
Thank you, Your
All
Honor.
right, folks. Okay, thank you very much.
Thank you,
Thank you, Your Honor.
That concludes this matter.
The judge once again proving to be the only adult in the room, calmly handling the courtroom circus while everyone else fumbles around trying to figure out if a message is a threat or just passive-aggressive family drama. Instead of indulging in unnecessary theatrics, the judge lays it out plain and simple. Keep the letters locked up, handle your own messes, and maybe, just maybe family members should stop acting like Twitter trolls with a law degree. But sure, let's keep pretending this is complicated.